1, 2,
And review, somebody email.
Oh shit, I got some blood going. Oh, he's wearing it too.
You're in the bay. Once you get over to the bed, we'll give you the story. Everything's going to happen super fast. Welcome to the emergency room.
I lost the phone.
It's, charter book.
300 please.
I'll keep your card again.
Pulse check. No pulse.
No more pulse.
Yeah. Here, what do the ECMO people say? And her blood pressure is off the property.
45 minutes of CPR and no return of circulation. Okay.
Oh.
Okay, let's unpack this. Imagine breaking your leg. You walk into the hospital, you get an x-ray, they set the bone, and you're put in a cast.
Right. Pretty standard procedure.
Exactly. But while you're sitting in that hospital bed recovering, you wouldn't expect the nurses to, suddenly intercept your sealed mail.
Oh, absolutely not.
You wouldn't expect them to confiscate your belt or restrict who's allowed to come visit you or, dictate who you're allowed to call on the phone.
Yeah, that would be a massive violation in a standard medical ward.
Right. But the moment you enter psychiatric care, the rules of reality just sort of change. Today, we're taking a massive stack of material on the legal and ethical realities of mental health care and really distilling it down for you.
It's so important because this area is notoriously complex.
It really is. So, using an 80-20 rule approach, this deep dive is going to be your high-yield mentor-style guide. We're finding out exactly where your civil rights end and public safety begins, giving you that core 20% of knowledge you absolutely must master for clinical judgment and safe patient care.
Because we're exploring a space where confiscating personal property isn't a violation of your rights, it's actually a clinical necessity.
Yeah, and that friction is fascinating.
The friction you're describing exists because a psychiatric ward is essentially a microcosm of society's most profound constitutional debates. But it's played out by clinicians on a random Tuesday afternoon.
That is a wild way to think about it.
I mean, if you're admitted for a fractured tibia, your legal rights don't vanish at the triage desk. But historically, psychiatric patients didn't have that luxury.
Right, they were essentially warehoused.
Exactly. Before the widespread reforms of the 1970s, individuals with severe mental illness were subjected to indefinite institutionalization with, virtually no civil liberties at all.
Which is horrifying to think about now.
It really is.
Yeah.
Today, the modern legal baseline dictates that a client receiving mental health care retains all of the exact same civil rights as any other citizen.
So they can refuse medication.
Yep. They can refuse medication, they can vote, send and receive unopened mail, and have visitors. The complexity only arises because overriding those fundamental liberties is sometimes literally the only way to keep the patient or the public alive.
But the bar to override those liberties is incredibly high, right? You can't restrict a patient's rights just because they're being difficult or loud or annoying to the nursing staff.
Oh, absolutely not. Any restriction requires a verifiable, documented, and immediate safety threat.
So if a patient is actively suicidal, taking their shoelaces and belt is technically a restriction of personal property, but the mechanism of self-harm is immediate.
Precisely. Or say, if a patient becomes highly aggressive every single time a specific family member visits, the treatment team can temporarily ban that visitor.
So the core tension is always balancing that baseline of total freedom with the visceral need for safety.
Right. And you see that tension immediately during the admission process itself, because, most admissions are entirely voluntary.
A person recognizes they're in a crisis, they sign themselves in, and legally, they maintain the right to sign a written request for discharge and just walk right back out the door.
Even against medical advice, the system is fundamentally designed to favor the patient's autonomy.
So when does that change? When does civil commitment actually happen?
The mechanism of civil commitment only triggers when that autonomy becomes lethal. Clinicians are legally bound to respect a voluntary patient's demand to leave unless the patient is an imminent danger to themselves or others.
Oh, wow.
Yeah, if they declare an intention to attempt suicide or if they threaten someone else, that voluntary status just shatters. The provider can initiate a 48 to 72-hour emergency hold.
Wait, hold on. I want to push back on this a little.
Sure.
So if I have a patient who is completely stable right now in the hospital, but their chart explicitly shows that the absolute second they go home, they'll stop taking their medication and inevitably become violent again.
Right, the revolving door scenario.
Yeah, exactly. Are you saying the law forces the hospital to just watch them walk out the front door and wait for a tragedy to happen? Do we just cross our fingers?
This raises an important question, and the legal system and the psychiatric community battle over this exact scenario constantly. You cannot hold someone involuntarily simply because they might decompensate in the future.
Even with a documented history?
Even with a history, the threat must be imminent. However, society eventually recognized that this cycle of hospitalization, discharge, relapse, and violence was failing absolutely everyone.
Right. It's not safe for the patient or the public.
Exactly. So the solution that emerged in many jurisdictions is a legal mechanism called mandatory outpatient treatment. It's often referred to as conditional release or assisted outpatient treatment.
Okay, so the court basically steps in and brokers a deal. You maintain your physical freedom in the community, but you surrender your medical autonomy.
That's a great way to put it. You are legally mandated to attend specific therapies, keep appointments, and take prescribed medications.
Does it actually work?
The data supporting this mechanism is incredibly strong. It's typically applied to patients with severe, persistent mental illness who have a documented history of frequent involuntary hospitalizations.
More criminal justice involvement, I imagine.
Yes, exactly. When courts mandate this treatment, we see significantly shorter inpatient stays and a massive reduction in mortality risk for these highly vulnerable patients.
That's huge.
It really is. It drastically protects them from criminal victimization while living on the streets, and it's infinitely more cost-effective for the state than funding repeated, catastrophic inpatient admissions.
Yet, despite the data, it's a massive infringement on constitutional freedom. I mean, it is the state literally dictating what chemicals must go into your body while you're sitting in your own home.
It is a profound ethical dilemma.
What's wild is that 47 states and the District of Columbia have laws enabling some form of mandated outpatient treatment. But 3 states completely opt out. Connecticut, Maryland, and Massachusetts do not have assisted outpatient treatment laws on the books. It just highlights how deep the ideological divide is.
Those states prioritize the absolute boundary of civil liberties. They argue that unless you are actively inside a hospital under an emergency hold, the government simply cannot force medical treatment upon you.
And we should probably clarify the difference between those emergency holds and something like guardianship because they get conflated a lot in public discourse.
Oh, constantly. Civil commitment is strictly about safety and psychiatric treatment. Guardianship, or conservatorship, is a fundamental ruling on competency.
Meaning what exactly?
If a court determines that a person has a severe cognitive disability, to the point where they are legally incompetent to provide basic food, clothing, and shelter for themselves, a legal guardian is appointed.
So the patient effectively loses the right to enter into any legally binding contract.
Exactly. They can't sign a lease, they can't manage their own money, they can't even get married without the guardian's consent. It's a complete transfer of decision-making power.
Wow. Okay, so we've established that we can legally strip a patient's physical freedom to leave the building or their freedom to make legal decisions.
Right.
But what happens when the danger isn't a person trying to walk out the front door, but a patient who is physically in the locked facility and suddenly becomes violently aggressive?
That is the highest risk safety scenario you'll face.
Right. How does a facility physically manage that without crossing the line into assault?
The entire framework for managing that aggression is built on a concept called the least restrictive environment. This isn't just a best practice. It is the constitutional foundation that actually drove the deinstitutionalization movement.
Okay, so what does that look like in practice?
It dictates that a client must be treated in the least restrictive setting appropriate for their clinical needs. If an outpatient clinic works, you cannot hospitalize them.
Makes sense.
And if they are hospitalized, they must be completely free of physical restraint or seclusion unless every other less restrictive intervention has completely failed. You try verbal de-escalation, you try offering oral medication, you try decreasing stimulation first.
Because to understand the gravity of this, you really have to look at the mechanics of the restrictions. A restraint is literally any method of restricting a patient's freedom of movement.
Yes.
It can be a human restraint, which is staff physically holding a person down. It can be mechanical, like leather restraints fastening a patient to a bed frame. Or it could be chemical, which is injecting a medication specifically to restrict their movement against their will.
And then there's seclusion, which is involuntary confinement in a specially constructed, locked room, stripped of absolutely anything that could be used for self-harm.
That sounds intense. What's the clinical justification for doing that?
The clinical purpose of seclusion is to forcefully decrease environmental stimulation, giving the patient an opportunity to regain emotional and physical control. But because the risk for abuse is extraordinarily high, the regulatory timelines are incredibly rigid.
I imagine they have to be.
Oh, they are. If you place an adult in restraints or seclusion, a licensed independent practitioner must perform a face-to-face evaluation of that patient within 1 hour.
1 hour.
Not at the end of the shift, not when they have free time, 1 hour.
And the monitoring requirements are just as severe. A patient in physical restraints requires continuous, uninterrupted, one-to-one monitoring by staff. You can't just lock the door and check on them later.
Exactly. Someone must be watching them the entire time.
In seclusion, it requires one-to-one observation for the first hour, after which audio and video monitoring might be permitted, depending on the facility's protocols. Plus, a formal clinical debriefing is required within 24 hours of releasing the patient.
But to truly grasp the weight of these interventions, you have to look at them through the patient's eyes.
Right. What did the patient say about it?
There is a profound disconnect between the clinical intent and the patient's lived experience. Staff often view seclusion as a necessary therapeutic intervention to ensure safety on the unit.
But the patients don't see it that way.
Not at all. Patients overwhelmingly report feeling terrified, angry, and helpless. They perceive the locked room not as a therapeutic pause, but as a punitive act. They report confusion about why they were locked away and what specific behaviors they even needed to exhibit to earn their release.
Honestly, many patients state that if staff had just taken the time to talk to them, or if they had been allowed to contact a family member, their escalation could have been entirely prevented.
It is a stark reminder that even when these extreme measures are legally justified and strictly monitored, they inflict a heavy psychological toll.
And here's where it gets really interesting. If a provider gets the mechanics of this wrong, it isn't just a lapse in clinical judgment. It instantly becomes a matter of legal liability.
Exactly. If you use a restraint inappropriately, you aren't just making a mistake, you are committing an intentional tort.
Okay, let's break that down for our listeners. What exactly is a tort?
A tort is a wrongful act that results in injury, loss, or damage to another person. In the psychiatric field, providers are uniquely vulnerable to intentional torts because they deal so heavily with non-consensual physical contact.
So, like assault.
Yes. Take assault, for instance. The general public equates assault with a physical attack. In legal terms, assault is the act of causing a person to fear they are about to be touched in an offensive or injurious way.
Okay, so if a patient is pacing the hallway and refusing to go to their room, and a nurse holds up a syringe of haloperidol and says, if you don't calm down and go to your room right now, I'm going to inject you with this.
That threat alone is assault.
Even if they don't touch them.
Even if they don't touch them.
No.
The nurse has weaponized the fear of forced medical intervention. Battery is the actual execution of that threat. It is the unwarranted, harmful, or offensive touching of the client.
So if that nurse actually administers the injection without consent and without a documented emergency justification, that's battery.
Exactly. And then there's false imprisonment. If a ward is short-staffed and a nurse decides to lock a demanding, annoying patient in the seclusion room just to get them out of the way, that is unjustifiable detention.
The patient has been falsely imprisoned under the guise of medical care.
Right.
Okay, so we've established that we can physically strip a patient's rights to protect the public, but there are massive legal consequences if we miscalculate.
Huge consequences.
But what happens when the danger isn't physical violence in a hospital hallway, but a secret shared behind the closed doors of a therapy session? We all know the baseline of medical privacy. The protections surrounding medical records are ironclad.
Right. IPA is no joke.
Federal law dictates severe fines and prison time for unauthorized disclosures. But how does the law handle a situation where honoring a patient's privacy could literally result in a murder?
The legal architecture for this exact dilemma was built in the aftermath of a chilling tragedy in California in 1969.
The Tarasov case.
Yes. A graduate student at the University of California named Prasenjit Poddar was receiving treatment from a university psychologist. During his sessions, Poddar explicitly confessed his intention to purchase a gun and murder his former girlfriend, Tatiana Tarasov, as soon as she returned from a trip to Brazil.
And the therapist didn't just ignore the threat, right? He actually notified the campus police.
He did. The police detained Poddar, evaluated him, and determined that he appeared rational. Poddar promised to stay away from Tarasov, so the police just released him.
And then the therapist's supervisor directed that no further action be taken, and the records of the threat were destroyed.
2 months later, Tatiana Tarasov returned from Brazil and Padar murdered her.
It's just devastating. Her parents sued the university, the police, and the therapists. The argument was that the therapist owed a duty not just to his patient, but to the intended victim.
If we connect this to the bigger picture, the California Supreme Court issued a landmark ruling that fundamentally altered the landscape of medical privacy. They declared, protective privilege ends where public peril begins.
Wow.
This established the duty to warn. The failure in the Tarasov case wasn't that the therapist did nothing, he called the police. The failure was that nobody warned Tatiana Tarasov herself.
But let's test the limits of this precedent.
Yeah.
Because in a psychiatric ward, patients say wild, violent things all the time. Paranoia and aggression are literally symptoms of the illnesses being treated.
Absolutely.
So, if a patient with severe schizophrenia is pacing the day room yelling, I'm going to get them before they get me, I'm going to kill everyone, does the nurse immediately pick up the phone and call the FBI to report a mass threat?
No, and this is where clinical judgment separates from simple reporting. The duty to warn does not apply to vague venting or generalized delusions.
Okay, so what triggers it?
For the duty to be triggered, specific criteria must be met. The threat must be serious. The patient must have the means to carry it out. But most crucially, the target must be specific, identifiable, and accessible.
So yelling, I'm going to get them, is too vague. There's no one to warn.
Exactly. But if the patient says, I am going to take my hunting rifle and shoot my former boss, John Smith, when he leaves the factory at 5 o'clock today, the threshold has been crossed.
Because John Smith is specific, identifiable, and accessible.
Right. At that moment, the provider's legal obligation to protect the public completely overrides the patient's right to privacy. The police and John Smith must be notified.
That makes a lot of sense. So we spend so much time analyzing how clinicians are held legally accountable for failing to prevent violence. But society also struggles immensely with how to hold the patients themselves accountable when they commit crimes.
The intersection of severe mental illness and the criminal justice system is incredibly fraught, and it is entirely encapsulated by the insanity defense.
The first thing you have to understand here is that insanity is not a medical diagnosis. You cannot open the DSM-5 and find criteria for insanity.
No, you definitely cannot. It is strictly a legal construct designed to determine culpability. And the gap between public perception and reality regarding this defense is massive.
The public often views the insanity defense as like this giant legal loophole, a convenient strategy used by criminals to avoid prison time.
In reality, it is invoked in less than 1% of all felony cases, and it is successful only a fraction of that time.
And the public outrage following high-profile cases where the defense was successful has actually led 4 states, Idaho, Kansas, Montana, and Utah, to abolish the insanity defense entirely.
They just got rid of it completely. In jurisdictions where it still exists, a jury isn't asked to determine if the defendant was simply mentally ill. They are asked to apply very specific legal tests.
Explain how a jury actually applies those tests, because the distinction between them dictates whether a person goes to a psychiatric hospital or a maximum security prison.
Let's use a hypothetical scenario. Imagine a defendant strangles someone, but due to severe psychosis, they genuinely believe they were squeezing a lemon to make juice. Under the Monotony rule, they would be found not guilty by reason of insanity because they did not know the nature of the act. They literally didn't know they were killing a human being.
But what if they knew they were strangling a person and they knew it was illegal, but the auditory hallucinations commanding them to do it were so overwhelming that they physically could not stop themselves?
Under Monotony, they would be guilty because they knew the act was wrong. But under the irresistible impulse test, they might be found insane because the illness destroyed their ability to control their conduct.
Are there any other tests?
Yes. The substantial capacity test blends these, asking if the person lacked the capacity to appreciate the wrongfulness of the act or conform to the law. And the Durham test simply asks if the criminal act was the direct product of a mental disease.
So the outcome entirely depends on which legal framework the specific state utilizes.
Exactly. But when violence does occur, whether it's directed at the public or directed inward, the legal fallout often lands back on the healthcare provider in the form of unintentional torts.
Specifically malpractice.
Right. Suicide is actually the highest risk liability in psychiatric care. But malpractice isn't just a bad outcome. It is a very specific legal chain of events.
Break that down for us.
For a malpractice lawsuit to succeed, 4 distinct elements must be proven, and they operate like links in a chain. First, duty. If you are the nurse assigned to a psychiatric unit, your duty to the patients on that unit is established the exact moment you clock in.
Okay, what's next?
Second, breach of duty. This means you failed to conform to the standard of care.
So if you have a patient who is actively suicidal and placed on continuous one-to-one monitoring, and you turn your back to answer a phone call for 5 minutes, you have breached your duty.
Exactly. The third element is injury. During those 5 minutes, the patient attempts suicide and suffers permanent brain damage from anoxia. The injury is clear.
And the last link.
The fourth and final link is causation. The plaintiff must prove that the injury was the direct result of the breach. In this scenario, the causation is absolute. If the nurse had not turned their back, the patient would not have been able to make the attempt.
All 4 links connect.
Right. If even one link is missing, for instance, if the nurse breached duty by looking away, but the patient simply sat quietly and suffered no injury, a malpractice suit completely fails.
So what does this all mean? All of these hyper-specific legal rules, the civil commitments, the torts, the duty to warn, the malpractice elements, they can feel like an endless maze of regulation.
It can be overwhelming.
If you strip away the legal jargon, what are we actually looking at for that core 20% that matters most?
Yeah.
What is the invisible architecture holding all of this up?
What's fascinating here is that every single legal or clinical conflict we have explored today is, at its core, a clash of fundamental ethical principles.
Interesting.
The hospital is simply the arena where society's deepest philosophical battles take place. The primary tug of war is between deontology and utilitarianism.
Let's define those. Think of deontology as a firewall built around the individual. It doesn't care what is happening on the broader network outside. Its only job is to protect the core system, the patient.
I love that analogy.
It argues that an action is morally right only if it respects the individual's autonomy and right to self-determination. The firewall says the patient has the absolute right to refuse medication, regardless of the consequences.
And utilitarianism is the network administrator. The administrator's job is to ensure the survival of the entire network. If one computer is infected and threatens to crash the whole system, the administrator will forcefully disconnect it.
So utilitarianism operates on the principle of the greatest good for the greatest number.
Yes. When a psychiatrist involuntarily commits a patient, they are acting as the network administrator. They are completely overriding the individual's deontological firewall to protect the broader public from harm.
You also have the principles of beneficence, which is the duty to actively do good, colliding with non-maleficence, the duty to do no harm.
Exactly. When you are evaluating a complex clinical scenario, you aren't just looking for a legal loophole. You are watching a clinician weigh whether their duty to do no harm to the public requires them to severely restrict an individual's freedom.
Recognizing which ethical principles are in direct conflict is really the key to understanding the mechanics of psychiatric law.
Is the lens through which every decision in this field must be viewed. It is never simply a binary choice between legal and illegal. It is a constant, delicate balancing act of competing moral obligations.
It really changes how you look at the whole system.
It does. And as we conclude this exploration, I want to leave you with a thought regarding the concept of the least restrictive environment we discussed earlier.
Yeah.
The deinstitutionalization movement successfully closed the massive abusive asylums of the past. The motivation was purely deontological, protecting individual autonomy and ending false imprisonment.
Which was a massive win for human rights.
Yes, but we have to look critically at the outcome. If shuttering those institutions means that populations with severe, untreated mental illness are now left homeless, segregated from vital community support, and constantly cycling in and out of the criminal justice system.
Are we genuinely serving the utilitarian greatest good?
Exactly. Or did we simply trade the abandonment of the asylum for the abandonment of the streets?
It's a profound question that challenges the very foundation of how we define progress.
Yeah.
It forces us to recognize that unlike setting a broken leg, the interventions in mental health care are rarely clean. The solutions are never perfect, and the cast doesn't always fix the break.
So true.
Keep looking past the surface of these laws, keep questioning the ethical frameworks, and we will see you on the next deep dive.